Imagine walking into a courtroom where the absolute highest stakes imaginable are literally on the table. We are not just talking about hefty fines or minor jail sentences here. We are talking about life in prison, or even the death penalty. Welcome to The Explainer. Today, we are stepping inside the Sessions Court of the Pakistani criminal justice system. When someone faces charges for the most severe offenses, think murder, terrorism, kidnapping, this is the arena where their fate is finally decided. The air is heavy in there. The procedures are incredibly rigorous, and literally every single word spoken can tip the scales between life and death. Today, we are unpacking exactly how the prosecution builds, structures, and presents its case in this high-stakes environment.
Okay, let's dive into this. What exactly happens when life or death is literally on the line? Because the Sessions Court occupies the absolute apex of the trial court hierarchy, it handles cases that your standard magistrates' courts simply cannot touch. So the procedures we're about to explore, they carry the heaviest consequences imaginable in the justice system. Over the next few minutes, we're going to look closely at the strict, unyielding rules the prosecution must follow to actually prove their case. We'll see how they lay the groundwork from start to finish.
So here is our roadmap through Chapter 22 of the Criminal Procedure Code. We'll cover recording evidence, the public prosecutor's role, dying declarations, retracted confessions, cross-examination, and finally a quick summary to tie it all together. Let's get into it.
First up, Section 1, Recording Prosecution Evidence, Laying the Groundwork.
When a trial formally begins, the prosecution always goes first. They bear the heavy burden of proof, which makes sense, right? Under Section 265E of the Cr.P.C, this process of presenting evidence is incredibly formal and structured. It's vastly different from an ordinary court hearing. Section 265E basically mandates that the court shall proceed to take all evidence produced in support of the prosecution on the fixed date. This means each witness is brought forward, examined in chief by the prosecution, cross-examined by the defense, and then potentially re-examined. But the critical difference in a Sessions trial is the extreme formality of it all. Every single question, every awkward pause, and every single answer during cross-examination must become part of the official, permanent record. Unlike a magistrate's court, where a judge might just jot down the general substance or a brief summary of what a witness says, the Sessions Court strictly requires verbatim testimony. The Sessions judge literally dictates the witness's testimony word for word. Absolutely nothing is left to interpretation. Alongside the spoken evidence, we also have physical and documentary evidence. These exhibits are formally tendered and marked for the record. For instance, prosecution exhibits get marked as Exhibit P1, P2, and so on, while defense exhibits get marked D1, D2. This strict cataloging ensures total clarity for everyone. Now, you might be wondering, why is this verbatim recording absolutely crucial? For that, we look to the 2007 Supreme Court case of Mohammed Shafik v. the State. The court explicitly held that recording verbatim evidence is not just some bureaucratic formality, it is absolutely essential to the appellate process. The Supreme Court reasoned that an appellate court's ability to reappreciate the evidence depends entirely on the accuracy and completeness of the trial record. Think about it. If the Sessions judge records abbreviated evidence, leaving out material portions of the testimony, the appellate court cannot properly assess whether a conviction is actually sustainable. If a judge merely paraphrases, they might omit a nuance that proves innocence. A judge who takes shortcuts here commits an error that can vitiate or completely invalidate the entire trial. Moving right along to Section 2, Public Prosecutor's Essential Role, State Representation. Now that we know how evidence is painstakingly recorded, let's look at the person actually orchestrating the state's case, the public prosecutor. This government-appointed law officer's role in the Sessions Court is highly active and incredibly consequential. Their job follows a strict chronological sequence. First up is the opening statement, where they present their theory of the case to the court before a single piece of evidence is even led. Next is the examination in chief, where they carefully structure questions to elicit evidence from their own witnesses to establish the necessary elements of the crime. Then, after the defense inevitably tries to tear that witness's story apart, the prosecutor has the right of re-examination. This is their chance to clarify any confusing matters raised. And finally, they deliver closing arguments, summarizing everything and arguing why the presented evidence establishes guilt absolutely beyond a reasonable doubt. And this brilliantly illustrates a vital concept about the prosecutor's ethical duty. Listen, they are not in that courtroom just to rack up convictions at all costs. They are actually there to help the court do justice. Look at the 2016 Supreme Court ruling in Zulfikar Ali v. the State. In this case, the court firmly held that if a public prosecutor makes a submission during closing arguments that mischaracterizes the facts just to secure a win, the Sessions Court must not blindly accept it. The court must assess the evidence independently. The holding makes it crystal clear. A conviction that rests on a prosecutor's mischaracterization of evidence rather than the actual evidence on record is fundamentally unsustainable. A prosecutor who stretches the truth isn't just being aggressive, they violate their core professional obligation. Which brings us to Section 3, Admissibility of Dying Declarations, the Final Words. This is a heavy one. Moving from the human actors in the court to the evidence itself, let's transition to what is arguably one of the most powerful and haunted evidentiary tools in a murder trial, the dying declaration. When a victim speaks their final words about who attacked them, the law listens very closely. Under Article 46 of the Qanun-e-Shahadat Order, statements made by a person regarding the cause of their death or the circumstances resulting in their death are considered legally relevant facts. But this isn't an automatic pass into evidence. There are 3 strict conditions for admissibility. First, the declarant must be in a fit physical and mental state. If they're delirious, it's inadmissible. Second, the statement must specifically relate to the cause of their death, not just random grievances. And third, and this is an absolute requirement, the declarant must actually die. If they miraculously recover, well, it's no longer a dying declaration. Let's look at how this plays out in a real trial scenario. Imagine a man named Rahim. It's 10 p.m., a pitch-dark night near the local bus stand. A sudden altercation breaks out, and Rahim is brutally stabbed multiple times by a man named Akbar. Rahim is rushed to the hospital, bleeding heavily but still clinging to life. Realizing the severity of his condition, the doctors urgently call for a magistrate to record his dying declaration. Despite his agonizing injuries, Rahim is conscious and completely coherent. The magistrate leans in and Rahim states clearly, "Akbar stabbed me with a knife. He said I had insulted his brother." It's a direct, devastating accusation from a dying man. 2 days later, tragically, Rahim succumbs to his wounds. Now we flash forward to the trial phase. Akbar is sitting in the dock facing murder charges, and his life is literally on the line. The prosecution introduces Rahim's recorded dying declaration as Exhibit P3. Boom. Immediately, the defense counsel jumps up to fiercely object. They argue that this statement shouldn't be admitted into evidence at all. The defense claims that Rahim was heavily medicated on painkillers at the time, making his mind cloudy and unreliable. Furthermore, they argue that there were no independent witnesses present during the magistrate's recording procedure to verify it. The tension in the courtroom is absolutely palpable. So how does the Sessions Court rule on this? Well, the judge meticulously breaks down the evidence step by step. First, they review the medical certificate issued by the doctor at the exact time of the recording, which definitively confirms Rahim was mentally fit and conscious, regardless of any medication. Next, the court verifies that the magistrate strictly followed all prescribed legal procedures, even without independent witnesses present. Finally, the judge notes that Rahim's description of the knife attack perfectly matches the postmortem report of the stab wounds. Because everything perfectly aligned with the objective medical evidence, the court completely rejects the defense's objections and fully admits the dying declaration. The sheer legal weight of such a statement is anchored by the 2009 Supreme Court case of Ghulam Nabi v. the State. Thoroughly unpacking this holding, the Supreme Court established that a dying declaration recorded by a doctor or magistrate in the prescribed form while the victim is conscious and coherent carries an incredibly high degree of reliability. In fact, if this statement directly names the accused and describes the attack in specific, consistent terms, it can be sufficient to sustain a conviction entirely on its own. No independent corroboration needed. That's massive. However, the court also mandated that these declarations must always survive rigorous, mandatory tests. They have to check the victim's fitness, the circumstances of the recording, and ensure total consistency with the medical evidence.
All right, moving to Section 4, Rules for Retracted Confessions, Changing the Story. Let's shift from a victim's final words to an accused's changing words. We are now moving into the highly contested evidentiary issue of confessions, specifically retracted confessions. What happens when an accused person confesses to a crime but then stands up during the trial and completely disowns their earlier statement? First, it's vital to know that under Pakistani law, a confession made directly to the police is completely inadmissible. History has shown why that's a necessary rule. The only legally admissible route is a confession formally recorded before a magistrate under Section 164 of the Cr.P.C. But if the accused later retracts that 164 confession during the trial, 3 strict rules apply. Number 1, a retracted confession is not automatically discarded. It remains part of the evidence. Number 2, however, unlike a dying declaration, a retracted confession generally requires independent corroboration to secure a conviction. It usually can't stand alone. And number 3, if the accused offers a credible explanation for the retraction, like asserting they were coerced or tortured by police, the court must heavily and carefully scrutinize those claims. This brings us to a landmark ruling, Mohammed Afzal v. the State from 2011. The Supreme Court drew a very sharp line regarding how to handle these retractions, detailing 2 very specific outcomes. Outcome 1. If the confession was recorded with all procedural safeguards, meaning the magistrate gave warnings and ensured adequate reflection time, and the accused later just casually claims they were tortured without a single shred of medical evidence or prompt complaint, the court can completely disbelieve the retraction and give the confession its full weight. Outcome 2. On the flip side, if there is credible evidence of coercion, such as visible documented injuries on the accused, a prompt complaint made right away to the judge, or glaring internal inconsistencies, the confession must be totally excluded. It gets absolute 0 weight. It all comes down to the objective evidence.
Now, what's really interesting about this next slide is how the defense fights back. Section 5, cross-examination in Sessions trials, testing the evidence.
We are looking at the ultimate weapon. The defense has to dismantle everything we just talked about: cross-examination. In a Sessions trial where life is on the line, the fundamental right to cross-examine prosecution witnesses is the absolute most critical tool for testing the truthfulness of the evidence. Defense counsels systematically target 4 core vulnerabilities during cross-examination. First, inconsistent Section 161 statements. This is when a witness's testimony in court wildly differs from what they initially told the police during the investigation. They will pounce on that. Second, they target interested witnesses. These are people with a motive to lie. Perhaps they have a long-standing family grudge or a bitter financial dispute with the accused. Third, they challenge ocular evidence and visibility. If the prosecution claims a witness saw the murder at midnight in a field with no lights, the defense will aggressively attack the physical possibility of that identification. Finally, they deeply scrutinize the chance witness. Someone who conveniently just happened to be walking by a desolate crime scene at the exact wrong time. The defense will hammer them to explain why they were really there, systematically introducing reasonable doubt to save their client.
The legal treatment of these interested witnesses we just mentioned was perfectly clarified in the 2018 Supreme Court case of Nazir Ahmad v. the State. The court detailed its exact reasoning, holding that just because a witness has a familial relationship with a victim or a bitter enmity with the accused, their testimony is not automatically disqualified. They can still take the stand. However, the court explicitly stated that such testimony must be scrutinized with particular care. It must withstand absolutely rigorous cross-examination and ideally be corroborated by independent evidence. If an interested witness's testimony is inconsistent, lacks outside corroboration, and totally falls apart under the pressure of cross-examination, the Supreme Court deemed that relying on it alone to convict is legally unsafe.
So the crucial point is that it's all intricately connected. Let's move to Section 6, Summary and Final Takeaways, the big picture.
A prosecution's case in a Sessions court is like a highly complex machine where every single gear must turn perfectly according to the strict rules of the law. We've covered a massive amount of intricate procedural ground today, so let's bring all these complex tools together for your rapid, quick reference summary. Number 1, under Section 265E, all evidence must be recorded verbatim. Abbreviated notes will literally destroy the appellate record. Number 2, the public prosecutor is a servant of justice, not a conviction machine, and they absolutely cannot ethically mischaracterize evidence. Number 3, under Article 46, a dying declaration is immensely powerful and can sustain a conviction alone, provided the victim was fit and it aligns with medical facts. Number 4, a retracted Section 164 confession isn't ignored, but it firmly demands independent corroboration and careful scrutiny for coercion. And number 5, the defense's cross-examination rights are fundamental, rigorously testing interested witnesses and exposing inconsistencies to protect the accused. When you step back and look at Chapter 22 of the CrPC, you realize something profound. These intense procedural safeguards aren't just bureaucratic red tape. They are the carefully calibrated scales of justice. They are designed to give the state the tools it needs to punish severe crimes while simultaneously providing a robust, interlocking shield to protect the accused against the horrifying irreversibility of a wrongful conviction. But it leaves us with a difficult question to ponder. Do these rigid rules perfectly balance the scales, or do they sometimes make it too difficult to convict the truly guilty? It's a debate that continues in courtrooms every single day. Want to master more intricacies of Pakistani criminal law and truly understand the mechanics of justice? Follow Pakistan Legal Insight for more deep dives into the procedures that govern life, liberty, and the law. Thank you so much for joining this explainer.